Good morning. Thank you all very much for being here and welcome. We're going to be the group of us as you can see, I'm with my colleagues, Sandra Casey, Barbara Lee, Gail Norris, and Joanna Silver. And we very much appreciate your being here with us this morning. The sort of genesis of this program today was thinking that we were sort of at the end of, or maybe the middle of thinking about COVID, and we were looking to be able to start taking a look at other things. Well, Omicron has surprised us a little, but nonetheless, I think we're still finding that for higher education, before the start for most schools of the second semester, that as there's an opportunity here for people to take a look and at some of the policies and issues that we really haven't been looking at in 2 years almost. And sort of turn our attention to those and kind of do a check-in of where things are on that. So what we're going to do today is talk about a number of issues. This won't be a back to basics. It won't be an ABC of these issues, since most of you are experienced higher education administrators. We know and assume that you are familiar with these issues. So we're really looking at this as a refresher to touch on particular issues or particular policies. And we'll be covering a number of different topics. The program is being recorded. And the recording and the slides will be available on the Bond website, which you should have access to. Usually it's about 24 hours after the program, so you should have access to this by late morning tomorrow on the website. So we encourage you to send questions in the chat function. We're hoping to have each speaker be able to answer a question or two. If you have suggestions for further topics, or if you have questions that aren't, that maybe go a little deeper and you'd like to see some additional discussion about some of these topics, please put it in the chat. We appreciate it, or feel free at a later time to email any of us directly as well. So I'm going to turn this over to my colleague, Sandra Casey, who is going to start us off by talking about FERPA.
Thank you, Jane, and good morning, everyone, and a warm welcome on this chilly day in January in upstate New York. I will get us started with the important topic of FERPA. I know this is not a basics course, but I do have to lay the groundwork somewhat so we all have context. FERPA is the federal law that protects student education records. The statute protects parents' rights of elementary and secondary students, which rights are transferred to the parent student when they enter a post-secondary educational institution. FERPA is enforced by the U.S. Department of Education's Privacy Policy Office, and schools must comply with FERPA as a condition of operating an educational program and receiving federal aid. There is no private right of action under FERPA, meaning that schools cannot be sued for a violation by a private party. But schools do face a loss of federal aid if they are found out of compliance. This is extremely rare. Also, though, we have to be mindful that there has been legislation proposed in the past that would penalize schools for FERPA violations, similar to what occurs when schools are faced with Clery Act violations. We hope that doesn't happen. Finally, there's always a reputational risk for non-compliance. So it's really a very important statute and one that we must all be mindful of. Next slide, please. So FERPA provides two fundamental rights to students at higher education institutions: the right to review their education records and the right to provide affirmative consent before an institution will disclose personally identifiable information, or PII, from their education record. Next slide, please. Most of us focus on the disclosure of PII, which we will discuss in a moment, but the student's right to review and inspect their education records is significant, and institutions must have procedures in place to comply with this right. Specifically, the regulations require that once a student makes a request to review their education records, the institution must respond within 45 days. The student's request must be specific as to what records they wish to review. Moreover, if a student requests an amendment to the record, the school must make a determination on whether the amendment will be made, and if not, the school must afford the student a hearing. The hearing requirements are minimal. Really, it is an opportunity for the student to be heard and can be in front of one individual who does not have an interest in the direct outcome of the hearing. But the school must issue a decision within a reasonable amount of time after the hearing and include the reasons for its decision. This is a separate process from a grade appeal, which is typically done through an academic department of a college pursuant to the academic handbook. One thing to note on the right to review records is that a student does not have the right to review their parents' financial information that the school maintains as part of the student's education record, typically in financial aid office. That restriction is specifically stated in the FERPA regulations. Next slide, please. Now let's turn to disclosures. The general rule is that a post-secondary institution must obtain a student's written consent before releasing any personally identifiable information from their education record. But there are many exceptions, which we will go through quickly. An institution can release without prior student consent information from a student's education record if the disclosure is to other school officials who have a legitimate educational interest and to officials of another school where the student seeks to enroll. Next slide, please. Disclosure can be made without consent to authorized representatives of the U.S. Comptroller General, the U.S. Attorney General, the U.S. Secretary of Education, or state and local educational authorities. Disclosures here may be made in connection with an audit or evaluation of or compliance with federal legal requirements that relate to these programs. Next slide, please. Disclosures without student consent can also be made if the disclosure is in connection with financial aid or is to organizations conducting studies for or on behalf of the school in order to develop, validate, or administer predictive tests, administer student aid, or improve instruction. Next slide, please. Disclosures without student consent can be made if the disclosure is to accrediting agencies, to parents of an eligible student if the student is a dependent under the IRS tax code, to comply with a judicial order or lawfully issued subpoena. The disclosure is in connection with a health or safety emergency, or if the information disclosed is designated by the school as directory information. Next slide. Institutions can also release to a victim of a crime of violence or a non-forcible sex offense the final results of the disciplinary proceeding in which the victim's alleged perpetrator was charged. Institutions can release to the general public the final results of the disciplinary proceeding in which the alleged student perpetrator was charged with a crime of violence or non-forcible sex offense, but only if the student were found responsible for such an offense and the institution has determined that the student violated the college's policies in committing the offense. Next slide, please. Disclosures of alcohol or controlled substance violation by a student can be made to their parents if the student is under the age of 21. And finally, disclosures can be made in relation to sex offenders required to register as such. Next slide, please. So that was a fast recitation, and I want to dive a little deeper into a few exceptions. For disclosures to school officials, such officials can include contractors, consultants, volunteers, or other parties to whom the institution has outsourced institutional services. If the school determines they have a legitimate educational interest, they conduct an institutional service for which the school would otherwise use employees, they are under the direct control of the institution regarding the maintenance and use of the records, and they are subject to FERPA's use and redisclosure requirements. A good example to highlight this rule is the school's use of threat assessment teams. Sometimes a school will ask a police officer to sit on the team. The police officer cannot redisclose any information they receive as part of their duties to the threat assessment team to other offices in their departments. Next slide, please. For disclosures relating to a judicial order or lawfully issued subpoena, the school must make a reasonable effort to notify the student in advance of compliance with the order or subpoena. Many times, a lawyer will issue a subpoena right before a hearing, 2 or 3 days. And when that happens, a school must call the attorney right away and ask for an extension to give the school a reasonable amount of time to notify the student. I'd say 7 to 10 business days is a reasonable amount of time to notify the student. If the extension cannot be given, then the attorney, really can resolve the situation by providing the school with the student's written consent so they can release the information. They may not always be so cooperative, but usually you can work it out. FERPA does provide instances where the subpoena can prohibit disclosure in advance to the student. This is allowed for in federal grand jury subpoenas or other subpoenas issued for law enforcement purposes. These subpoenas must state on their face that they are to remain confidential and their existence or the contents of the subpoena are not to be disclosed. Sometimes the subpoenas do not state this on the face of the document. So it is always a good idea to contact the official serving the subpoena and ask for clarification. If they state that the student cannot be notified of the subpoena, then they must reissue the subpoena with the appropriate prohibiting language. For disclosures relating to health and safety emergencies, the institution may look at the totality of the circumstances in determining if an emergency exists. If the institution determines that there is an articulable and significant threat to the health and safety of a student or other person, it may disclose the education record to any person whose knowledge of that information is necessary to protect health and safety. Next slide, please. For disclosures relating to the release of directory information, the regulations give clear guidance on what could be considered directory information, which is listed on this slide. However, schools may wish to limit further and may not want to release students' addresses in order to protect them from an invasion of privacy or worse, threats such as stalking. Also, you must be mindful of state privacy laws. For instance, in New York, schools cannot use students' image or likeness for marketing purposes, say on a website or in a brochure, without the student's consent. Schools must also provide students with the right to opt out of the directory policy each year. This could be done as part of a requirement to annually notify students of FERPA. Once students opt out, there should be some kind of confidentiality flag, I'm having trouble with that word today, on their record in the school student information system to prohibit any release of directory information without their prior consent. So speaking of the annual notification requirement, it is a good idea to look at section 99.7 of the Code of Federal Regulations under Title 34 to make sure you have all the elements required in that notification. Next slide, please. FERPA also allows institutions to disclose de-identified records without prior student consent, which helps with the work of institutional research offices on your campuses. Next slide, please. This is a big one, and this is a good reminder for people. You must be mindful of record-keeping requirements under FERPA. Except for disclosures to school officials, disclosures related to some judicial orders or lawfully issued subpoenas, and release of directory information, all the other disclosures must be recorded with the student's education record. Therefore, it is a good practice to train all departments that release FERPA protected information on logging disclosures that need to be recorded. The campus's registrar's office is often the place where the disclosures are recorded. Therefore, coordinating the training with the registrar's office is really best. Next slide, please. There are records which are not considered education records. Law enforcement records created by law enforcement units, medical treatment records. Next slide. Employment records, except for records of students who may work at the institution. Records created or received by the school after the student is no longer in attendance and do not relate to this former student's attendance. These are often referred to as alumni records. Grades on peer-guided papers before they are collected and recorded by the faculty member. And finally, records kept in the sole possession of the maker. This is a very, very narrow exception. And in order for it to be used, the document cannot be shared with anyone except a temporary substitute for the maker of the record. Next slide, please. On this slide, I have included some recent resources that are good tools for you to use as you revisit your FERPA policies and practices. The U.S. Department of Health and Human Services and the U.S. Department of Education issued joint guidance on the interplay between FERPA and HIPAA. That's a very important document. The Congressional Research Service issued a report on FERPA just recently, back in May of 2021. And even though I should not mention COVID-19 because we're trying to get away from that in this presentation, the Department of Education did issue FAQs and guidance on disclosures relating to COVID, both in March of 2020 and September of 2020. So that concludes my remarks on FERPA.
Excuse me, Jane, it appears that you're still muted.
Good morning again. Thank you, Sandra. And let's move on to the topic of student conduct policies and procedures. Do we have the slide up? I apologize, I'm not seeing it. Apologies, I'm just getting a blank screen. So I will do this with my own copy and move through it. Apologies for that. So the first slide, as you can see, is really sort of a reminder to you that codes of conduct can come in many shapes and sizes, and they're all going to be different based on the different features of your institution, and that you have choices about the way you structure your policies and the kinds of choices you make. Next slide, please. As the title says, periodic review is really critical for student conduct policies. These are not the kind of policies you're necessarily going to look at every year or every other year, but certainly at points, it's really important to look at them, to ask yourselves, those of you who work with these issues at the institution, why certain provisions are in there and if they're still necessary. Thinking about values and how they play out. I think this is really a very good time after the exhausting last few years to take a look and, if possible, have the folks in the departments, student affairs, council, diversity, public safety, take a look back at some of the student discipline matters, student conduct matters that you've worked on over the last few years. Were there any gaps in the policy that were made it difficult, or perhaps that students may have kind of exploited to avoid some consequences? I think this is a good time to look back at some of those experiences and come up with any thoughts you have on addressing those in the policy. Sort of the last point is really a reminder that you can make your codes very detailed. You can make them very sort of fluid and loosey-goosey and sort of being somewhere in what your campus's sweet spot is in the middle of is important. And that we are on to the next slide, which I think really gets to that point, which is about clarifying the policy, making sure it's clear and managing expectations. And it's a really critical point that students need to understand clearly how the policy works, policies work, what their rights and responsibilities are, and to be as transparent as possible about sanctions in the way that we have been directed to be in Title IX policies. I think that we've learned that it's helpful for complainants, for respondents, for witnesses, for the community to understand what some of the range of sanctions that are typically used on the campus, what those are. It's always important to make rules and processes easy to find on your website and to work with students. Certainly, I've heard a number of times when students can't find the right policies, so they make other complaints under different policies that may be difficult to address. So that's an important piece. In addition to the disciplinary or adjudication part of these policies, it's really, although not legally required, it's important to have a grievance process where students can make complaints about other students, about faculty, what have you. We are, I think, all aware that in the disability law area, institutions are required to have a disability accommodation grievance process. This is something different from that, but it's important that it be in your policies. It's important that it have an appeal process. There are ways to combine processes or separate them out. That's really the choice of the institution. Probably more institutions tend to separate out different grievance policies, like academic policies, disciplinary type grievance, conduct type grievance processes, and disability processes. Those more institutions tend to separate them, but it's not required. I think it's worth noting that there are many advantages to having a grievance process, including it's a real safety valve. Sort of students don't immediately go running to court. There's an administrative process that they need to use. Also, it really is an early warning system that the campus can see. Are there problems in a particular department or with a particular group or club of students? So strongly recommended to have the grievance process. Next slide, please. I will take a moment to just make a note about COVID, because over the last almost 2 years, we've had a lot of discussions about, do you have COVID violations as part of your code, or do you have it separate? And this again is a matter of choice for campuses. Happy, to talk with any of you about some of the pluses and minuses of doing it different ways. I think you'll want to look back at what your institution did and see how it worked for you and how circumstances now may be a little bit different. I put on the slide a few places that had some different approaches and want to note that one kind of theme that we did see in during the really since March 2020 was the elevation in seriousness of certain kinds of housing violations that ordinarily would not have been treated as tremendously serious. But now, for example, a guest policy where people are bringing in unknown, unidentified, unwanted people into the residence hall, that some campuses are treating those more seriously and adjudicating them even under the code of conduct, even if they have a separate sort of residential policy. So that's kind of a trend that is interesting. There are issues about behavioral contracts. These are not things that you want necessarily to use for every single thing that a student is doing and have them sign 16 contracts as they're coming onto campus. But I think I'm going to talk at a few places where there may be benefit in some brief language with students acknowledging that they've received certain documents and are going to abide by them, and that they understand that's a condition, and that they could potentially be disciplined for violating them up to and including expulsion. Next slide, please. Social media, which is of course everywhere and creates all kinds of interesting issues and problems. Just going to touch on how this relates in certain ways to the code of conduct. Be very clear. Our advice is that to be very clear that social media behavior is behavior and it's conduct and it's covered. And so if, the sort of a prime example is someone making threats or telling someone they're going to get them for making a complaint, if that happens on social media, that's retaliation and needs to be addressed. So important to sort of bring that and make sure students are aware that this is your expectation. The campuses may want to consider, if you have a social media policy and best practices, you may want to consider putting that as part of or an addendum to your conduct policies or including it there. And if you don't have such a policy, it may be instructive to think about one, which would be a document I would recommend that is a kind of campus-wide endeavor, including some students, faculty, and others. Next slide, please. Off-campus activity, and of course, social media in many ways can be characterized, when it's on students' private social media accounts, can be characterized as off-campus activity. As a general matter, institutions are able to choose generally whether they wish to regulate off-campus behavior or not. Private institutions have a little more leeway than public institutions do to regulate this. Public institutions have to be more aware of not violating any constitutional rights. And I noted here the recent Supreme Court cheerleader case where we saw that the Supreme Court found that a high school was chilling, or not just chilling, but had disciplined a student for her profane and disrespectful comments on her private social media. And of course, what's good for high school in the Supreme Court, colleges will never be, would never be able to discipline that kind of speech in the wake of that decision. But with respect to conduct, to off-campus conduct, there may be very good reasons to want to discipline or not. So I think that's the choice of the institution, but it's crucial that you make clear in your policy if the institution does exercise jurisdiction. And I think it's helpful to be clear about having that activity have some connection to the campus and to enforce those kinds of parts of your conduct code consistently, which may mean that you have to treat people who say things that you agree with or protest about issues and you agree with them the same as people who protest about issues and engage in behavior that you don't agree with. So you really do need to be very consistent in the way that you address these kinds of off-campus behaviors. Next slide, please. One issue in particular about social media that's been can be very vexing relates to the student use of their personal social media in clinical settings. And those, whether it's nursing or funeral service or medical or others, there have been some very unfortunate court decisions that have limited colleges from being able to discipline students who have posted mocking or derisive or very or angry posts about their patients that they're seeing in a clinical setting, posting photos, private, inappropriate photos, and other issues. And unfortunately, in several cases over the last number of years, courts have required schools to take back students that they've expelled for this kind of behavior, and really sort of putting schools and programs in a very, very difficult place. So no guarantees that you can set your conduct policy in a way that will, you'll magically be able to do everything you want. But there are some things that campuses can do. And I think our recommendations would be to focus on the documents at the program level, because the program, the way to have the best chance of being able to succeed with disciplining students is to be very clear about the specific behaviors that are problematic, that tie them to specific professional standards, and to give students an understanding of potential sanctions, specifically mention that this can be sanctioned even though it is their own private, personal Facebook page, Instagram, Twitter, whatever it is. And I think it's also important from an educational point of view to students in these program documents, program handbooks, and other documents to explain why it can cause harm, how it can cause harm to families, to patients, to the program, to future students, and to the clinical site. And this is a case where I think programs would be wise to have students sign acknowledgements of receiving the program handbook and to that they understand and are going to abide by those. And I think taking those kinds of precautions can be very helpful. So I encourage you to work with your program deans to help make sure that program documents include those kinds of protections. Next slide, please. Hate speech is a topic we could spend all day talking about, and we aren't going to today. But I want to talk about, we all know that hate speech codes have been uniformly struck down by courts, and there are some alternatives for campuses to think about with dealing with issues that might include hate speech, but also include certain kinds of conduct to be able to address some of these very hurtful issues. But again, I think it's important that the conduct code, in terms of managing expectations, that we are clear that certainly for public institutions that there isn't going to be discipline for speech, but really that what campuses should be addressing is behavior and effect of behavior rather than intent. But non-discrimination policies can be useful for some of this conduct. And I'm taking a leaf here from the book by my colleague, Barbara Lee, who is on this program, her book, The Law of Higher Education. And she and her co-authors point out that sort of behavior that's kind of communicative behavior, where somebody may be shouting slurs at the same time as doing other things, spitting, hitting, blocking entranceways, and so forth, that behavior can be addressed, even if it's coupled with speech. And of course, a reminder that, of the importance of consistent enforcement and treating like behavior alike, regardless of content, when there's similar kind of controversial situations. The last point I'd like to talk about on the next slide has to do with bias intervention teams, also sometimes called campus response teams. These have been very useful structures that campuses have worked with to help address in a non-conduct way issues of bias that can use a different approach. However, there's been a continuing campaign, as most of you may know, of legal challenges to these teams by a group called Speech First that has been bringing lawsuits all around the country. And there have been several circuit court decisions that have found these teams to be unlawful, in particular because the courts have found that they chill speech because they're, in a nutshell, sort of too much like a disciplinary process, and that they make students fear that they're going to be punished for what they say and what they think about controversial topics. I commend to you the NACUA note that I refer to on this page for some terrific discussion of this and for some techniques to try to make your bias intervention team, if you have one, as as bulletproof as possible. But I would also note for those schools that are in New York, a reminder that New York has a hate crimes statute, as do many other states. And in New York, Article 129A of the education law has a requirement that all colleges are supposed to provide programming and information to incoming students about the procedures that the campus uses to deal with bias-related crimes. So I think that's one area that a lot of us and folks on campuses don't necessarily think of immediately. But if there is behavior that could possibly rise to the level of a bias-related crime, I encourage campuses to work with their public safety and encourage students and others to report those to law enforcement, because there is that avenue that takes it out of the school's jurisdiction, but is a possibility. I would also say that the programming and materials that a campus is required to develop for this is a good opportunity to have this material in writing in one place and to be able to make sure you train staff about what these procedures are and what they aren't, so that you're all following the same procedures. I will add, on the topic of training, I will just add one final note before I wrap up on this topic, which is all of these terrific policies that you're working on. It's really critical to remember that training of staff who work with the policies is important, so that everybody's on the same page and you don't have wonderful policies that are not being implemented and not being used on the campus. So with that, I'm going to conclude. If I'm not sure if we have time for questions at this point, so I am going to put it back to Sandra Casey for some discussion of study abroad. Thank you.
Thank you, Jane. Very informative. Thank you very much. So these next few slides will focus on items in which I have had experience counseling clients on study abroad programs. Next slide, please. Many institutions will have in place agreements with foreign partner institutions to host their students. So these agreements often contain language protecting the foreign institution's policies and obligations under their governing law, but you have to be sure to include language protecting your own institution's policies and governing laws. Everything has to govern the student's experience overseas. There should be provisions governing student privacy under various laws, such as FERPA, which I talked about at length, the Gramm-Leach-Bliley Act, which protects financial information. Also, if the foreign institution is located in the European Union, undoubtedly there will be requirements under the General Data Protection Regulation, GDPR. So you have to ensure that your rights under GDPR are protected in the agreement. For instance, under GDPR, there is an allowance for the student to be forgotten. So they have a right to be forgotten, and their records can be deleted or scratched, but such right is superseded by the institution's business necessity to retain that information. So we have the right as US institutions to retain that information in our records. So again, you have to make sure that your rights are protected in that agreement. Next slide, please. The partnership agreements with foreign institutions should also contain language which really clearly spells out the costs borne by each institution and what the student is responsible for. There also should be teach-out provisions in the event the program has to be canceled during the semester or other academic term. We all saw this when study abroad programs were canceled in March of 2020. It was very important to have teach-out of these students because they would have lost their credit otherwise. And another thing you should be mindful of is third-party provider agreements. Residential agreements. Sometimes third-party providers provide residences for the students. They provide programming. A lot of activities overseas are done through third-party providers. So you have to ensure that those third-party provider agreements model the institution's policies, especially with respect to non-discrimination policies. You should review all the materials the student will be required to sign, and that if the third-party provider requires the student to sign a release for like a high-risk activity, you want to make sure that the release does not negate the release that the student must sign for your institution. Next slide, please. Requiring health insurance is a must, student health insurance. It's very, very important. This is especially helpful for repatriation, where you have to get the student back quickly, or sadly, the student dies overseas. You know, all my daughters participated in study abroad programs, and I insured them and their phones to the max. I wanted to make sure that I could contact them day or night, but I was always very good about giving them space. So what most schools are concerned with when operating study abroad programs is negligence, a negligence action if the student is hurt. The case law actually favors non-liability on the part of the institution where it can be shown that the student assumed the risk of the activity. That is why it's so important for schools to have students sign a comprehensive release which outlines all the known risks on the particular program the student is participating in. It's also best that the release include the host institution and any third-party providers. If the release includes third-party providers, then the school does have some leverage with those providers to not require the students to sign their additional waivers. So that conflict that might arise with the third party providing the student with release is negated if, you know, the third party providers' rights are protected in the institution's release that the student must sign. The release to the student also acts as notice with regard to costs that they are required to pay and what happens if the program is canceled. You know, the teach out provisions, you know, everything that needs to go in there to put the students on notice to what to expect. It is also really important with regard to behaviors for which the student can be disciplined for when they come back to the home institution. This is that off-campus behavior conduct that Jane spoke about. I mean, if you put notice in the release itself that they can be disciplined for behavior that occurs overseas, then they won't be surprised when they come back to the institution and face charges. Another area that's really important is non-discrimination statutes applicability. I'm going to be talking a little bit later in the program on civil rights statutes, but really the important takeaway here is regardless of whether the civil rights statute is applicable in the foreign jurisdiction, U.S. institutions still have obligations to not discriminate in offering student abroad programs, study abroad programs. So therefore, if your institution provides study abroad programs for all students, you have to make reasonable accommodation for a student, say, who's disabled and may not readily be able to participate in a certain program, you do have to engage in an interactive process with the student to make sure that you're providing reasonable accommodation for that student to be able to participate. Next slide, please. So another area of consideration is the Clery Act. The federal, you all know, is the Federal Crimes Reporting Act that we're required to comply with. So foreign campuses owned or controlled by US institutions are required to report Clery crimes if they have an organized program of study and administrative personnel on site. An institution that has a study abroad program at a location or facility that the institution does not control will not be responsible for reporting crimes at those facilities. However, if the institution rents or leases academic or program space for students in a hotel or student housing, it is considered in control of that space for the time period covered by the rental agreement or lease. So again, the Clery Act reporting requirements are triggered there. Host family situations do not normally trigger crime reporting responsibilities unless the written agreement with the family gives the institution some significant control space in that family's home, but that's pretty rare. So really, these are just the top level considerations I asked you to think about as you go back to offering study abroad programs to your students. And I would be happy to take questions after we run through this program. And I will now turn it over to Barbara Lee. Thank you.
Thank you, Sandra. You've given us a lot to think about. Even though we think we know a lot about study abroad, you've given us even more information. It's very, very helpful. So now we're in January 2022. And although we have been back on campus, and maybe not all of us are back on campus now with that ugly word COVID, there's been quite a bit going on in the area of laws related to sexual misconduct by students and employees. So that's what I want to talk about now. As you know, the Office for Civil Rights is going to start rulemaking in April 2022. They announced that, and that means that they will have draft regulations for us to look at in April of 2022, which is not that far away. Once that process is finished, we'll all likely be revising our policies, but there's one area where policy should be updated right now, and I'm going to talk about that in a couple of minutes. While we're waiting for the new Title IX regulations, you might want to use this opportunity to consider helpful efforts, such as in-person training, where most beneficial, and I'll be mentioning that later on in my presentation, additional climate surveys for special populations, fostering peer mentors or other positive student activities. You also may want to think about an issue that Jane raised, and that's your bias response teams. There's going to be a client alert coming out from us in a couple of weeks about bias response teams to give you perhaps a little bit more help with that issue. Next slide, please. So what to do now? Okay, I think I've already talked about that. So the next slide, please. So let's talk about what we know now about Title IX. Well, as I think we all know, the US Department of Justice and the Biden administration has told us that the definition of sex in Title IX has been expanded to include both sexual orientation and gender identity as a result of the Bostock Supreme Court ruling. And recall that religious colleges can require a Title IX exemption. So we may be seeing more of those because of this expanded definition of Title IX to cover sex. The Title IX regulations promulgated by the Trump administration, as we know, are still in effect, but there is an exception, and I've put that in bold, so you'll take notice of that. The language that follows is now not lawful. The Trump regulations had said if a party or witness does not submit to cross-examination at the live hearing, the decision makers must not rely on any statement of that party or witness in reaching a determination. That language was struck by a federal judge in August of 2021, saying that it was arbitrary and capricious, and the judge applied that ruling nationwide. So if you have this information in your policy, you should change it and certainly not follow that, that language. It means that information gathered during a Title IX investigation now may be used at a hearing, even if the source of that information is not cross-examined. And this is very important because the now ineffective language would have stymied hearing officers or panels from considering relevant information if the informant simply refused to attend the hearing or refused to be cross-examined. So this is good news. We don't get a lot of good news from Title IX very often, but this is good and helpful news for us. After the April 2022 OCR announcement of proposed rulemaking, there will be a public comment period, and then the final regulations will be released. And my crystal ball isn't good enough to tell you when that will be, but they have a minimum of 60 days. I suspect it may take longer than that. It took a lot longer than that the last time they were revised. Just want to mention a very recent case. It was announced 2 days ago under Title IX. And it's quite a change, I think, for those of us who follow Title IX. There was a lawsuit brought against a Pennsylvania State University by the parents of a student who was murdered in her residence hall room by a non-student boyfriend with whom she'd had quite a long relationship. The parents sued, arguing that the university was indifferent to the concern of to the safety of the young woman. The Third Circuit, which is where the case was recently decided, said it could be deliberate indifference, sent it back for a jury trial. So this was not an employee, this was not a fellow student, this was a non-student personal relationship. And it's possible that a jury can find that that institution was deliberately indifferent. So we're clearly going to be wanting to follow that case. Next slide, please. So now what do we know about Title VII? Well, as again, the Bostock case expanded the definition of sex in Title VII to include sexual orientation and gender identity. And that is the ruling of the court. It did not address Title IX, but the regulatory agencies have done that for us. And what this means is that this is the law throughout the United States. The court did not address specific issues such as employee resistance to or teaching individuals whose gender identity or sexual orientation may make them uncomfortable or may even be, in their viewpoint, against their religion. But we know from the long history of litigation involving race discrimination and, quote, customer preferences, that individual disinclination to interact with coworkers or students is not a defense to a discrimination claim. The possible exception might be colleges whose close relationship with a religion whose doctrine disapproves of non-traditional sexual orientation or gender identity. And there's actually a case that was decided in the Northern District of Texas in last October called Bear Creek Bible Church and Braidwood Management Incorporation, where this is in its early stages, but a Christian business sought a declaratory judgment seeking a religious exemption to Title VII. This is not a Title IX issue, it's a Title VII issue, so that the EEOC could not act if the Christian business refused to hire or fired, and these are the terms the business used, these are not my words, homosexuals, bisexuals, cross-dressers, transgender, or gender non-conforming employees. And the business imposes a gender-related dress code, requires married employees to be married to spouses of the opposite sex. Restrooms are limited to the same biological sex employees, etc. The October 2021 case had ruled a summary judgment for plaintiffs on some of these issues. So again, I think that's something to watch. Student employees or non-student employees may bring EEOC charges or lawsuits where they couldn't before on the basis of sexual orientation or gender identity. And Bostock actually may have an impact on state non-discrimination laws. There are about half the states in this country have non-discrimination laws that do not protect individuals against discrimination on the basis of gender identity or sexual orientation. So there may be litigation or legislation making changes in some of those laws. The name, I wasn't going to mention the name of the case because it's so difficult, but if the questioner will email me, I'll be glad to give you the information and the citation. Okay, the next slide, please. How about special concerns when a faculty member is a respondent in a Title IX claim? There has been a lot of litigation involving colleges that moved to discipline or dismiss a faculty member as a result of being found responsible in a Title IX complaint, but without following the formal discipline or dismissal process in the faculty handbook. And faculty have typically prevailed in these breach of contract claims because the institution did not follow its contractual disciplinary policy or dismissal policy. So if the Title IX process finds a faculty member responsible, you'll need to consult your handbook or policies for the discipline process. And the institution must follow the discipline process, even if the Title IX process does the fact finding. This may mean that the Title IX hearing must address issues that would be relevant to the requirements of the discipline or dismissal process. So then, questions. Does your handbook allow for the hearing committee or the grievance panel to accept the Title IX fact finding, or must they consider the evidence all over again? Unless the handbook is unusual, it probably doesn't address this issue, and therefore the handbook would need to be followed, and perhaps that would require a complete rehashing of the evidence presented at the Title IX hearing. What standard of proof does your faculty discipline process require? Typical Title IX processes use the preponderance of the evidence standard, but faculty discipline policies on many campuses require clear and convincing evidence, a higher standard, in order to find a violation of institutional policy. The AAUP policy statements provide for the clear and convincing standard, and many faculty handbooks use this. So the standard for establishing responsibility for a Title IX violation by a faculty member could be different and lower than the standard for determining whether or not the faculty member has violated the institution's sexual misconduct policy or other policies. And this may lead to different results in the Title IX hearing, finding responsibility for the faculty member. From the discipline hearing, perhaps finding the faculty member not responsible. And how will your institution handle this outcome? What do your policies say about what happens when a disciplinary hearing panel finds a faculty member not responsible for violating a policy when the Title IX hearing found responsibility? So that's something to think about. Some faculty handbooks do provide for the ability for the administration to disagree with a faculty panel, but that may be at best a political problem and perhaps sometimes a legal problem. Next slide, please. So how about when the student brings a Title IX claim under this expanded definition of Title IX? Perhaps previously, these complaints involving gender identity or sexual orientation could only be brought under the institution's Code of Student Conduct, or perhaps they were treated informally. Now they can be subject to a Title IX hearing process. Are your Title IX staff trained and competent to deal with potentially different types of factual scenarios, given these additional identities and complaints related to these new categories? Will the same type of approaches used for survivors of gender-based violence be appropriate for addressing concerns of victims of sexual orientation or gender identity discrimination? And very importantly, and sometimes not thought about, do chairs and deans understand the broader definition of sex? Are they equipped to respond to student or faculty complaints related to these issues? Because they may be the first person the student talks to. And if the chairs are not aware of this change in the definition of sex or their responsibilities under the law, there may be problems down the road. Can you use cases brought under your student code of conduct as training examples? And I think you will definitely need to train both your Title IX staff, your student affairs staff, your housing staff, and deans and chairs about these new protections for students and employees, actually. Next slide, please. So how about student Title IX respondents who manage autism spectrum disorder. There have been a few articles written about this lately. I thought it was interesting and worth spending a minute on. Research has found that approximately 2% of all college students have been diagnosed or managed without diagnosis autism spectrum disorder. Again, according to research on these students, many face special challenges interacting with others, understanding unwritten rules about personal space or social interactions, or understanding the requirements of functioning in a college environment. According to experts, and I have a quote here, and I've put the source of that quote at the bottom of the slide, the social challenges for a student on the autism spectrum include problems understanding others' perspectives, sharing space and making eye contact. Many high-functioning individuals with an autism spectrum disorder have extreme social anxiety and have difficulty negotiating with others and interacting and working in pairs or groups in the classroom or outside the classroom. These students likely will not understand the unwritten classroom etiquette and will often misinterpret facial expressions or other nonverbal cues. This can be particularly problematic when a student who manages autism spectrum disorder is accused of a conduct violation, particularly when involving Title IX. They may have difficulty understanding the reasoning behind the complaint, may not be effective at explaining their actions, and may not understand the consequences of their actions. So consider issues involving student complainants or respondents who manage autism spectrum disorder. Their disability may make self-advocacy or testimony difficult for others to interpret or understand. And there are a few published court opinions involving student plaintiffs with autism spectrum disorder who were disciplined as a result of conduct violations. Plaintiffs at colleges where they were not offered support or assistance in meeting with conduct officers or dealing with disciplinary hearings were at times successful in challenging the discipline imposed. Although the percentage of these students on most campuses is small, certainly, it might be helpful to have some staff trained in this area in order to support students with autism spectrum disorder and head off conduct problems before they occur. There is a very helpful NACUA note. Next slide. I think I have one more slide, right? Next slide, please. Yes, thank you. So there's a helpful NACUA note called Accommodations for Disabilities in the Title IX Grievance Process that talks about a wide variety of disabilities, not just autism spectrum disorder. And I commit it to you for your review in dealing with not only these students, but other students who may have mental health issues, may have other disabilities that complicate the process of teasing out whether there was a Title IX or some other conduct violation and helping them then advocate for themselves. So that's a brief overview of the whirlwind of changes in Title VII and Title IX. And now Gail is going to talk about cybersecurity.
Thanks, Barbara. That was a great presentation, a lot to think about. My segment's going to start segueing more into the work environment than the student environment. We've got a couple of topics for you to end our program. Next slide, please. The first topic is let's do a little bit of a checkup on what's been happening in the cybersecurity space. We have the regular alphabet soup of cybersecurity rules that are still applicable, and there are still ongoing enforcement actions under many of them that provide some guidance on what we all should look out for. The thing I'll particularly note here is there is a growing number of states that have their own privacy laws. They apply to students, and we've been dealing with that, starting with California's expansive law a while ago. But as more states are added to the list of regulations on personal information, and our employees may be working remotely in those states, we need to pay more and more attention to them. I understand, for instance, that Florida is on the verge of passing its own new privacy law for residents of the state of Florida. There's been a couple other things that have been going on in the COVID years. The next important one, I think, for higher ed is in April of last year, the Employee Benefit Security Administration came out with a cybersecurity guidance that impose fiduciary responsibilities for cybersecurity. The good news, I guess, here is that there's nothing new in the cybersecurity guidance in terms of extra precautions institutions have to take that aren't already applicable in a bunch of the other alphabet soup of laws and regulations that apply. But what this guidance does do is clearly link responsibility for cybersecurity to a sponsor, a record keeper, or another fiduciary, such as an investment advisor, to ERISA fiduciary responsibility. So it's been the first sort of expansion to the ERISA fiduciary framework in some time. I think the main takeaway as a result of that is that plan sponsors or your 403B committee, for instance, should be making sure that they do document what their compliance efforts are as a plan sponsor for the 403B information that you're keeping for your employees, and that you've documented some diligence of your record keepers and your investment advisors, if they're fiduciaries to your plan, to see what their cybersecurity protections are. And I know this has been a big area of concern. I think TIA in particular, TIA Craft, which a lot of places use for record keepers, was a little slow to adopt the two-factor authentication for privacy. So I think there's going to be a lot of effort made in an industry that maybe hasn't been as cutting edge on cybersecurity as there have been in the past when it comes to ERISA service providers. Then in May of last year, Biden issued an executive order on improving the nation's cybersecurity. This was a very ambitious executive order. I think there's 35 or 40 initiatives for cybersecurity that were announced high level in this executive order. Most of them deal with the security of our government infrastructure to protect information, but that always morphs into some concern about federal contractors. And then when you talk about federal contractors, you start to worry about grant administration. And indeed, there are anticipated new federal acquisition regulations and defense FARs that are probably going to come out that have some enhanced cybersecurity protections. Notice of proposed rulemaking is expected in February. As many of you know, in your grant administration area, many of these FAR and DFAR clauses are brought into contract to grants, even though they're not technically contracts. So we may be subject to them as the rules come out. We need to keep a look at that. I think the areas that people are expecting the most change is a clear requirement now for notice to a federal agency if there's been a cybersecurity breach. That's been less clear in the past, but I think it'll be tightened. And there is expected to be some new contract provisions that will be incorporated into government contractors that deal with cybersecurity responsibilities. And again, we can expect that some of those will be applicable to some of the grants. And then as anywhere with cybersecurity, industry standards continue to develop. NIST, which is sort of the go-to agency for looking at best practices in cybersecurity framework, just came out with guidelines over the past year on software supply chain security. And while that doesn't have direct application, I think, for institutions of higher education, it does get to the issue of third-party vendors, and we're going to touch on that a little bit. And there was a really good guidance presented on cloud security. And we've all morphed from our servers to the cloud on a number of our software applications, thinking, we don't have to worry about it anymore. It's not on our own servers, but cloud security is starting to be a bigger and bigger issue, and cyber criminals are starting to look at cloud security. So it's an area we need to pay some attention to. So the bottom line is this area continues to be really dynamic. There's no such thing as being impervious to cybersecurity risks. So we need to keep up to speed on what's going on. Next slide, please. Oh, I'm just going to run through, what we all know is sort of the main components of the cybersecurity compliance program, and look at maybe some adjustments that may need to be thought about or made to what we've been doing in these areas, given the amount of remote work that's been going on. The first area is to have foundational written policies and procedures, and there may be some remote work adjustments here, particularly in how individuals are using our information assets and what access controls are there. Mobile devices are being used more and more. Wi-Fi protection is different. You get an employee who wants to go to Starbucks for the morning and work and is using Starbucks Wi-Fi to log into the network. There may be some security concerns there. What do we need to think about those policies, and do they need to be revised? And then training. How are we continuing to train people to be aware of the cyber risks? And if there are new concerns in the remote work environment, are we getting that information out? Risk assessment activities, major component of cybersecurity compliance, and sort of the cardinal rule is know what your PII is and where it is stored. And the question to ask is, has this changed in the remote work environment? Are there people working from home that are putting things on jump drives to be able to go back and forth? Has there been new tools implemented to allow remote work? That means that PII may be in places it wasn't before. And as many of you know, all these compliance areas are somewhat interactive. So if your PII shows up in a place where it hasn't been before, what do we need to do in terms of maybe changing policies, or maybe looking at the next area, which is cybersecurity program design and safeguards, to see what we need to institute in order to make sure we're still on the ball with the compliance program. Now, in the cybersecurity program design and safeguards, the investment in data security controls, especially with a more and more remote environment, can be limitless. Encryption is a big thing. A lot of institutions are thinking about giving all employees encrypted jump drives so that if there is information that's copied in order to be able to take home, that the jump drive's protected in case it gets lost. Antivirus software on a lot of home devices is something that's being talked about. Networks segmentation within an institution so that one breach can't worm its way into other areas of your IT systems, are all things that are being improved upon with new opportunities. And it leads to an unlimited budget that could be assigned to IT in order to come up with these data security controls. And obviously, no institution has a limitless budget. So there's a real risk assessment that I think probably boards and senior leadership need to be involved in talking about where that balance is of being secure, but still managing a budget so that you can afford to do other things. And then in the cybersecurity program design and safeguards, we always have what I call the special snowflake problem. And this may be exacerbated with the remote work. And it's, for instance, the faculty member that says, I have a grant with a colleague at another institution and we're sharing this particular file, and our firewalls are making it difficult for the file to be shared. So can I move it outside of our firewall so that I can share this with my colleague? That's one example, but I know in most institutions there are a number of requests for exceptions for data to be exchanged outside of the IT architecture and infrastructure that's been designed to protect data. That can be a tough balance in your IT people fighting with primarily your faculty, but I will tell you that most instances of at least faculty data breaches come from this special snowflake problem. They come from a knowing revision to what is otherwise a secure environment to allow faculty to work more easily that inevitably results in a breach where they happen. So it's something to be concerned about. Make sure you're supporting your IT people if there are exceptions that are making your entire system vulnerable in order to accommodate a faculty member. Next slide. Incident response is an important area. I think these, like any kind of disaster or emergency control plan, need to be refreshed regularly because they can get stale, but you should also consider whether or not there needs to be some adjustment needed for remote work. If people aren't able to meet in a conference room, if there's a potential breach, how do you get people together? What kind of adjustments may be needed in your incident response? And then never should we forget about third-party service providers. There has been a lot in the news and being discussed recently with contract terms with third-party service providers, especially in higher ed and healthcare, where you find some new innovative apps with smaller vendors who insist on limitations of liability in their contracts. So they are not willing to take responsibility because it would clearly sink them for any cyber breach that's due to their application. They'll limit it to the amount of their contract, for instance. And more institutions who are anxious to get their hands on some of these apps that may help remote work or provide some opportunities to students or faculty find those hard to negotiate against. And it may be that your own liability policy, which we'll get to in a minute, might help protect against that and provide some coverage, but it's something to pay attention to. A lot of people that are negotiating these software purchases may not be as savvy as others and understanding what they're signing. So you got to make sure you've got a really good process in place to look at your third-party service providers that are providing software that can have cybersecurity implications. Next slide, please. Okay, insurance and cybersecurity is a really dynamic area. I just had a client tell me yesterday, and although they're not in the higher education space, they're in a related space, that their premiums for cyber insurance increased 300%. And while that's unusual in the magnitude of the increase, I think everyone's seeing pretty substantial increase in cyber insurance premiums that are making people look at coverage. And along with the coverage issue, there are some automatic exclusions being included in a lot of the big providers' cyber insurance policies. One of them that you often see as an exclusion entirely for cyber extortion for ransomware attacks. So you do need to pay attention to what your insurance renewals are like, what the premiums are like, and what your coverage actually is. And again, you can cover data breaches due to third-party vendor vulnerability, and that would be a good area to cover if you are finding that you need to negotiate contracts, as I mentioned before, that have some of your vendors limiting their liability for breaches on their own. Employees remain a key area of vulnerability. There's phishing scams that are going on all the time. I know there's one out right now with Amazon that's getting into business environment where you click if you want to take an Amazon survey, I think. So reminders and training. I know employees have been inundated with dealing with things in our COVID environment, and sometimes training in this area can get put on the back burner, but it still is the main source of cyber problems in all institutions, and we need to stay vigilant. There are remote work issues, and I'm going to go into remote work generally next and touch on a lot of this again, but with mobile devices and VPN dial-up connections, there are new cybersecurity vulnerabilities, as I mentioned before, wireless or unsecured networks that aren't as safe as the ones you have in your work environment. And then enhanced cybersecurity risks in the remote area often come from short shortcuts. And these are 3 examples that we've seen with clients in our firm. You know, employees who download personal information that's protected onto an unencrypted jump drive or onto a mobile device in order to take it at home and be able to manipulate it more easily. That can cause problems if the jump drive is lost. Even if you don't know that there's been a breach, you likely have a reporting obligation. Employees that send emails with PII attachments to their personal email address for the same reason. Personal email addresses, if it's Google or similar cloud providers, are not as secure, and there could be breaches that occur there that are much more difficult to track because you don't have the security devices to detect breaches on home email systems. And then employees that physically take sensitive information home, you know, maybe financial aid files gathered up, taken home. What happens if a file gets lost along the way, or how do you keep track of that? Okay, next slide. I'm going to move on in the interest of time to remote work. The good news with COVID, I guess, is that it did accelerate solutions for many of the barriers that prevented remote work, and particularly in the area of technology. I think we can all acknowledge that if you were doing a Zoom meeting from home, that wouldn't have been very typical pre-COVID, but now it's become the norm. So there are good news for allowing more technology solutions for remote work to make it even a possibility. It was something that we all had to deal with when we had shutdowns, and there have been a lot of remote work accommodations and policies that have been developed in what I would call a reactive way in having employees work remote for the first time. But as we move to a new normal that might involve some permanent hybrid or remote, 100% remote work being done by employees, I think it's time now to shift from what was a reactive process to a more proactive one, and really thinking about what issues arise with remote work. And as we've come to expect with most new frontiers, the issues related to remote work, especially compliance risks, are complicated. And there's a lot to consider. So I'm going to just go through a checklist with you, again, not in any deep dive, but just give you some food for thought and a checklist to think about. Next slide. Okay, the first one is, and again, I'm going to assume in most of this that there's other work locations outside the state where your institution's doing business, and we'll get to the possibility of international work in a minute. But if you're in another state, if you have an employee who's working remotely in another state, and it is not just for a temporary period of time, you need to consider 2 concepts. One is whether the institution's doing business in the jurisdiction, and that has to do with registration with the state, or it could be the county in some cases. And then the other one is, do you have a threshold for creating a taxable presence for state or local tax reasons? Those 2 tests are a little bit different, and they are a matter of state law in many cases. So you need to look at each state and figure out whether or not you do have to register or qualify to do business. And then if there's taxable presence, what you need to consider for income tax, employment taxes, workers' compensation, and other local taxes when you're paying your employee who's permanently in another state. Telecommuting policies, if they haven't already developed, probably do need to be developed. The biggest, most difficult area is ground rules and eligibility. In any institution like most of ours, it's not one size fits all. There are some employees, like your janitorial staff or your facilities folks, that can't work remotely, and there's others where it might be more easy to, how do you define eligibility to make sure it doesn't look too arbitrary or variable across your organization. What do you do with the situation, like, for instance, somebody wants to work in Florida for the month? Is that kind of thing going to be allowed? What are the particular things that should be, thought about if someone's doing an Airbnb and working from there for a while? The issues on who can work remotely and what they need to pay attention to and what the institution needs to pay attention to are pretty limitless when you get thinking about it. And I'm sure a lot of you have already seen a bunch of the issues that arise with special requests to work remotely in various situations. There's more and more talk of having employees actually sign contracts and liability waivers. I'm not sure about the enforceability of those, but if you're going to work remotely, there are so many obligations that are transferred from the employer to the employee in the remote working environment that a particular contract that an employee signs saying, I'm aware that I have all these new obligations that I didn't have before, is starting to look like a better and better idea. Still controversial in a lot of places, but again, I think something you really should be thinking about. How do you deal with workplace setup and accommodation requests? Do you have your OSHA people go into a work environment to help set up ergonomic workstations so that an employee doesn't have some of the carpal tunnel or other issues that have been around with ergonomics in the workplace for a long time? What do you do about things like printers or other types of equipment that may be needed for the employees beyond a computer? If the employee's in another state, do you pay for travel if they're coming back to the campus for a particular reason? And what are the rules on what travel will and won't be covered? How do you get office supplies to them? Usually we have some pretty good vendor contracts in place because of the volume of supplies that are purchased at an institution. If everybody can run to their own staples for office supplies, your costs may go up if they're all reimbursable. What do you do with mail if a employee is remote? How is mail get directed so that the employee can get it, but it's not being sent to their own house? And then a big question is do you allow work outside of the U.S.? That loops back into the taxable presence and doing business section, because there are some really significant issues for employees that may be permanently working in another country. Many countries don't have the same kind of rules on tax-exempt organizations as are true in the U.S. So tax considerations in particular can be drastically different. So you need to really pay attention to that and see whether it's something in your bandwidth to be able to allow and to be able to handle how you get your hands around what that looks like if you do have an employee there. I know there are some employers who have gotten around it by contracting with a local institution in the foreign country to actually employ the employee through that organization, and then to do an employee lease agreement to lease them to the institution to use, and the institution can reimburse the foreign institution for all the employment costs related to it. That may work in some jurisdictions. This is a suggestion. Next slide. Employee benefits needs to be considered. I think the biggest issue there is medical coverage and networks. If you have an employee in another state, you've got to make sure that there is some network coverage so that they can get doctors and still be covered by the health insurance you offered them, or otherwise make accommodation for medical coverage for the employee. There's workers' compensation laws that differ in every state, and you will be subject to workers' compensation law in the state where the employee is working. So you need to figure out what those are. There are different local paid leave laws in every state, so you're going to need to pay attention to those. There is a question about whether New York's, which is one of the broader ones, would apply for paid leave if you have an employee working in another state. Those issues have to be considered, and you need to make some policy decision on whether you're going to apply your home state's laws, if they're more generous, to the employee who's working in a state that might have less generous leave laws. And then there are some special rules in various states that are hard to know what you don't know. In California, for instance, remote workers have to have individual health coverage mandate, and you've got to report that to California. So you need to know that so that you can report if you have an employee based in California. Wage and hour requirements, there's been a lot written on it. We're running a little bit tight on time, so I'm not going to go through it because you're probably already familiar with it, but it is a lot harder to track compensable work for hourly employees who are working remotely and ensure they take the required workload breaks, and how you control the work so you're not subject to overtime and with the employee working in a remote environment. Next slide, please. Workplace safety. You are indeed responsible for workplace safety of your employee when working from home. I think the OSHA standard of remote work employees, and whether it's a work-related safety incident or injury, is whether it's directly related to the performance of the work rather than to the general home environment setting. It's a little bit of an amorphous test, but if an employee has a whole bunch of cords for their printer and computer and other devices plugged in, and they trip over the cord on their way to the kitchen, is that a workplace injury that's got to be reported? Do you have to pay workers' comp from that? How do you monitor to make sure that your employees are setting up their work environment to be safe? You don't want a whole bunch of cords maybe plugged into a power strip that doesn't have the right surge protection or other load controls on it. What are the other workplace safety things you should be thinking about that you got to make sure your employees are aware when they set up their work environment? You know, whether, again, ergonomics, lighting, other types of things. Remote employees have to report work-related injuries. Again, it's hard to determine what injury is work-related when you're working from home, but they should be aware of them. And certainly if they're going to claim workers' comp, they need to report it to you. There are a lot of workplace safety posting requirements by OSHA as well as state regulators, and you need to make sure somehow that those posting requirements are met for remote workers who aren't in the workplace looking at a bulletin board. And again, there are definitely local laws in different states on workplace safety that you're going to need to get up to speed on if you're going to have a permanent worker in that state. We've already talked of privacy and security in the cybersecurity space, so I won't delve into that anymore, other than to say, you know, I do think supervisors need to pay attention, particularly to what work will need to be taken home, what PII might be in the home office, the extent to which there is going to be PII used in the remote work force would increase concern about Wi-Fi protection, what files are being taken home. Again, another area where it may be a good idea to have a contract in place so that the employee recognizes the sensitive nature of that work that they're exporting to their home environment to make sure that there's the kind of protection requirements that you would have inside your work environment. And then there's an ongoing debate about how to monitor performance when you've got remote workers. How do you keep employees engaged? How do you keep them properly trained and connected to the environment? the work environment. Next slide, please. Luckily, there aren't that many intellectual property issues. That's one you can skip unless you have allowed employees to work in foreign locations. And if you have, then you do need to pay attention to the export control laws in the US. There is a lot of information that we work on every day in a higher education environment that you don't typically think of being as export controlled, but it is. And having that information in foreign countries may raise the specter of some licensing obligations for the institution if that data is going to be present in that jurisdiction. Are there special insurance requirements? Not talking about cyber insurance now, I'm talking about just regular insurance for employees in remote location. Property damage is one of them to think about. If there is expensive equipment that's going home with an employee in order to do their job, do you require the employee to have homeowners policy protection? Can you get property insurance at that location on your own policy? Does your cyber security policy cover breaches that happen from remote location? Is there an exclusion for that? What other type of insurance things do you need to think about? Is there any particular auto liability issues? It's just a different environment when you have remote workers. Hiring in HR has been a big issue, especially during lockdown when there's been new jobs that have to be hired for, but nobody can come into an office for an interview. So I think there are more and more HR solutions coming out that allow interviews to be conducted remotely and for technology to be used in the typical type of hiring paperwork that's needed for signatures and for checking things like I-9s, which Joanna's going to get to in a minute. So the whole hiring area, I think your HR people need to pay attention to it. Many of the solutions are cloud-based, and again, that may raise some cybersecurity issues for the type of information that's being transferred in the hiring process that often includes Social Security numbers at a minimum. And sort of a totally different type of awareness, but I do think this area, because it's not a one-size-fits-all across your institution, and maybe there's been authority delegated to the department level to make some of these remote work determinations, you need to be aware of the possibility of unequal application of policies that have a disparate impact, giving rise for discrimination claims. And again, this risk would be differ from different organizations depending on how centralized your policies are or how they're being applied across different types of employees and departments. But it's something to at least keep your eye on as you digest what your remote work policies are going to look like. And then the final point is that the more and more institutions are dealing with remote work and have these kinds of policies and solutions in place for it, the more I think it's changing the continuum of whether telecommuting is a reasonable accommodation for a disability. It's not going to be as hard to accommodate that as it might have been in the past. And given that clear employee sentiment is to work from home, I do think you can all expect some accommodation requests for disability to be working in a remote environment. And that's all I have for today. I think I'm going to turn it over to Joanna for immigration.
Hi, everybody. As my colleague said before, we had intentions to try to distance ourselves from COVID a little bit in presenting these items to you today. But I think the reality is what we've learned, or at least I know I've learned listening to my colleagues talk for the last hour or so, is that COVID has altered the way we do things on our campuses, and it continues to alter the way we do things on our campuses. And that holds true with respect to immigration compliance. While the world has slowed down, so to speak, a little bit in terms of immigration, with our US consulates and embassies being closed and the various travel restrictions that have been in place with respect to COVID, there still are a lot of compliance issues that our campuses should be taking a look at. Next slide, please. I'm going to focus pretty quickly because we're running out of time on three main areas for compliance. One is Form I-9 work authorization verification. The second one is the H-1B visa program and the related labor condition applications. And the final thing is actually just a little thing about making sure you change your address with the Immigration Service. Next slide, please. So going back to March 2020, for those of us who can remember, that was the start of the pandemic. The Immigration Service gave employers a little gift when it came to completing the Form I-9 work verification procedures. Prior to the pandemic, if you were onboarding an employee to your company, somebody in your company would have to do in-person inspection of the individual's documents, identity and work authorization documents that qualify them and prove that they're authorized to work for you. And our government recognized pretty early on, thank goodness, that they would have to accommodate that process in order for employers to onboard individuals during the pandemic. And that allowed those on your campus to remotely inspect documents instead of doing in-person inspection of documents. And employers have spent the last 2 years on occasion looking at documents over Zoom, by fax, by email, all with the caveat that when we're back on site, that in-person verification of original documents will occur. And I know I've got a bunch of clients who have forgotten about the caveat now that some of their employees are back on site, and there is a lot of legwork that has to be done to make sure that that in-person inspection does occur. This flexibility with respect to Form I-9, thankfully, has been extended by our government. Every couple of months or so, we kind of hold our breath to see if it's going to be extended for another period of time. And most recently, they extended the flexibility through this April 30th, 2022. So for individuals who you onboard who are working exclusively in a remote setting, you can continue to do the remote inspection of their documents. And when they return to non-remote employment, or when the flexibility is ultimately terminated by the Immigration Service, you will have to do in-person inspection of their documents. There is, the government is taking comments actually from a lot of employers to see about maybe permanently instituting the ability to check documents remotely. I'm sure there'll be more to follow on that, but for now, these are the rules that we need to follow. And as I mentioned at the beginning, the most important thing about this flexibility is that when the individuals have returned to on-site employment, your organization must conduct physical inspection of their Form I-9 documents within 3 business days of them returning. And you have to modify the person's Form I-9 to indicate the date on which the in-person inspection of the documents were done, along with the name of the person who did that in-person inspection of the documents. One small item that I want to mention that's not on this slide is that a lot of people's documents have expired over the course of the pandemic. I, for one, my driver's license in New Jersey expired, and New Jersey is one of these states where you had to go in person to renew your driver's license, which I was not going to do. And then eventually you were able to renew your driver's license over the web. They finally saw the light. So I was able to extend my driver's license, but that's not so in a lot of different states. So when somebody brings you an expired document like a driver's license, what you want to do is basically see if the issuing agency has made some sort of an exception for that expired document. For instance, they've automatically extended it until further notice or something along those lines. And then you can accept that as a LISP document to prove the person's identity. So just little things to look for with respect to that. Next slide, please, Kathy. So one option that, I always try to remind my clients of is that, and that comes up a lot because as, you have more locations throughout the country, or if you have individuals who are working remotely through the country, completing a Form I-9 can become kind of difficult, and you do have to do it within the first 3 days of the person's hire. So over the years, even pre-pandemic, some institutions have relied on engaging agents in order to perform this function for them. So for instance, if I'm in New York and I have an employee who's working in California, I can engage an agent to do in-person inspection of that individual's documents and complete Form I-9 on their behalf, and that's done on behalf of the institution. I just want to remind you that this is a permissible option. It was a permissible option before the pandemic. It's a personal option. I'm sure post-pandemic, this will be an option for those of you who are having difficulty completing Form I-9 for remote employees. Another good thing to keep in mind, I often have employers call me and say, I can't find a notary public to do this function for me. The individual who's working as an agent for the institution does not have to be a notary public. The person just has to be somebody who's authorized by the employer to verify the work authorization and identity of the individual and complete the form on behalf of the institution. That being said, because the ultimate liability, should you be audited, is on the institution, it's important that the person who is serving as the agent has some familiarity with what they're looking for and completing the form, because it is the employer who's going to be responsible for whatever errors and mistakes are made, and if those errors and mistakes are caught during an audit. So just something, to keep in your back pocket if for some reason you can no longer use the flexibility options that are available to you as a result of the pandemic. Kathy, next slide, please. I'm going to move on to the H-1B visa program, which a lot of you use to onboard international faculty members and other employees at your campuses. And for those of you familiar with the program, you know that the labor condition application, which is filed with the U.S. Department of Labor, is the document that controls the location of where the work will be performed, restrictions on where individuals can work. And the reason for that is because it focuses on the prevailing wage for the employment. And as we know, prevailing wage differs from location to location. What a professor might make in New York City could be very different from what a professor makes in Idaho. So we do submit these documents with the H-1B visa petition to discuss the prevailing wage for the job, where the individual is working, and what the institution is paying the individual. When the pandemic first started and we started having a lot of employees moving to locations to work, whether in their home or another state or an Airbnb or wherever they ended up working, that was okay for most of our employees, and we didn't have to be that concerned about it other than the issues that were raised by Gail in her presentation. But with respect to H-1B workers, we did have to be concerned because we've attested to the location where they're going to be working and the amount of money that they're going to be paid based on where they are working. So there were obligations that occurred and employers had to pivot pretty quickly in terms of notifying, providing the notice requirement that the individual had changed their location. And this required the usual posting requirement of 2 places on site for 10 days, which became an interesting situation because we literally had people posting LCAs in their kitchens and their bathrooms because that was their new location for working, and the notice requirement had to be fulfilled. In some circumstances, if the individual was working outside the area of intended employment, which is generally considered to be outside of regular commuting distance to their job, we had to file a new LCA with the Department of Labor, as well as an amended H-1B visa petition with the Immigration Service. This is always the case, but really rose to a certain level during the pandemic. So this is something that employers even now have to continue to follow up on. So my suggestion for compliance is that it's always a good idea to check your H-1B visa files and your labor condition applications to make sure that that you are reflecting where people are working and that their prevailing wage is being met by the salary that you're being paid to them. An important thing to keep in mind is we as employers, we actually fund the audit that is done pursuant under the H-1B visa program. As you know, in addition to the USCIS filing fee for these petitions, employers pay a $500 fraud prevention and inspection fee. And this is where your money goes. Your money goes to allowing our government to come in and audit our H-1B visa petitions and labor condition applications. And this area does seem to be pretty ripe for audit. I have heard from other individuals that these audits are happening. And the most important thing about them is that they're surprise audits. So you can be sitting in your office one day when somebody just walks in and tells you that they're there to audit your H-1B visa files, your public access files, to make sure that everything is in compliance with the H-1B and the LCA program. So have a look at your employees in this category, make sure everything is up to speed, and that way you'll be prepared in the event of an audit. Next slide, Kathy. Employees' change of address. So because we've had a lot of movement, it's important that your non-US workers know that if they change their address, they have to notify USCIS within 10 days of making that move. And if they don't do this, they could have penalties down the road. In addition, if they're expecting documents from the Immigration Service with respect to their cases, they may not get those as well. So it's important to do this. And even if the individual, sometimes the individual just changes apartments. Here in New York City, I get the call all the time. I just moved down 2 floors. Do I have to file it? Yes, you have to file it. Anytime you move, file Form A-R11 with the Immigration Service, and the individual should provide HR with a copy of that as well so that the address is updated across the board. And I am out of breath and out of time, so I'm going to pass this on. I think Sandra's up next with some civil rights information, but if you have any questions on the issues that I discussed, I'm sure you will know how to reach me. Thanks very much.
Hi, everybody. So in the interest of time, I'm going to just highlight very quickly the civil rights statutes. Next slide. These are the ones that are triggered by the program participation agreement that institutions signs when they sign up for Title IV aid. It's also triggered generally when any entity receives federal aid. There's Section 504 of the Rehabilitation Act, which is the ADA counterpart. There's Title VI of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, and national origin. There's the Age Discrimination Act of 1975. And then, of course, there's Title IX of the Education Amendments of 1972. So these particular provisions, they apply to publics and privates universally, and something that everybody should be concerned with. Next slide. And I just wanted to highlight really quickly Section 504 because there has been an uptick of everybody who is suffering from mental health issues, faculty, students, especially in light of the COVID pandemic. These mental health issues have been exacerbated. And so people with mental health who are suffering from any kind of mental health issues could be considered disabled, and they are then protected under Section 504, which is very similar to the ADA, which is enforced not only by OCR, but also by the Department of Justice. Next slide, please. So campuses really should ensure that they have in place all policies and procedures to respond to any allegations of discrimination, regardless of the basis. As Barbara mentioned, there's specific regulations that must be used when responding to acts of sexual violence or misconduct under Title IX. But there's so much more that we need to be concerned with, and we have to make sure that all our policies are up to snuff. And then I just wanted to mention quickly that there is tension between, there was attention noted in the Title IX regulations when they came out in the comment and the preamble about Title IX and FERPA, which I talked about at the beginning of the program. And basically the thinking is where there's a conflict between a Title IX complaint, responding to a Title IX complaint, and protection of education records under FERPA, the Title IX due process requirements will supersede FERPA. And there's a good discussion of this in the Congressional Research Service report, which I've highlighted here on this slide. Next slide. I think we're done. So thank you for taking the time to listen to me, and I am going to turn it over to Barbara.
Okay, Sandra, thank you very much. We apologize for running over by about 3 minutes. We want to be respectful of your time. So I'm just going to give very brief comments. We picked issues we thought you might want to know more about, but we know there are a lot more, many more. To answer a question, a recording of this webinar and its slides will be on the Bond website tomorrow. All right, so you'll have full access to everything tomorrow. If you have additional questions or you would like advice or help about any of these issues or others, or if you have suggestions for future topics for webinars, which we always appreciate, please contact any of us. All of our email addresses are on the Bond website. Normally it's the first initial of our first name and our last name at bsk.com, but we're on the website. It's easy to contact us. Thank you for coming today. It's been a pleasure. Thank you for your good questions, and we'll see you again sometime.